Well, thank you, Paige, and hello, everyone. Thank you for joining us for today's webinar. As you heard in Paige's introduction, we're fortunate to have two national experts in community association law and insurance with us today. So I'll spend just a few moments briefly setting the table, and we'll let them carry the bulk of today's presentation. Joel, George, and I all enjoy speaking to a live audience, whether live in person or live online. So if any time we have a question for you and we want your feedback, we'll ask you to raise your hands. And the way you do that is by clicking your hands raised icon in your control panel. It's similar to, again, what you see on screen. So let's test that out. Grab your mouse and give me a hands raised click if you're ready for us to get going on today's presentation. Very nice. I see hands going up, all up and down my list. Very good. Don't get too far from that. Okay, I'm going to click hands down. And here we go. What we want to start off with is the concept that reserve expenses are some of the largest expenses an association are going to face, but fortunately, they're predictable. You can see them coming years in advance. And that's an important concept because these reserve expenses are so large, they take years of financial preparation to get ready for them. And that's why I lead off with this quote here from Benjamin Franklin: "By failing to prepare, you are preparing to fail." Now, we've summarized reserves pretty simply. We don't want reserves themselves to get complicated with the 4 reserve rules. Number 1, expenses are inevitable. The board is responsible to manage the expenses of the association. Delays in executing those major projects usually result in the projects getting more expensive, and the homeowners always get stuck paying the bills. And the point of this program today is to emphasize that underfunding reserves is a big avoidable mistake. Reserve deterioration is real, ongoing, and I'll say it again, predictable. Replacing or repairing those assets due to deterioration over time is not an insurable loss. Board member decisions to underfund reserves may be defended by your D&O carrier, but you, or per the last slide, the owners, will still need to come up with the money to replace that roof or the asphalt. And that's why I'm going to lead out with this proposition that it's reckless for a board to just blatantly disregard their responsibility to take care of the assets of the association and subject the association to financial surprises from things that failed gradually and predictably in plain sight over the course of many years. And the result is unsightly and expensive deferred maintenance. And like here, where in addition to having to replace the roof, they're now going to have to spend a lot of money on interior unit repairs. There's going to be all these problems, and that creates special assessments, if not assessments, loans, dropping property values, and increased board member personal liability. So in a conversation one day at a conference, I found Joel and George that they were also concerned that a majority of the associations were underfunded, and this was just a looming big problem, that boards were regularly failing to budget for adequate reserve contributions. And they said, "Hey, Nordlund, what's going on here? How come they're not doing this?" So started talking, and that discussion led to a common understanding that failing to set budgets that offset this ongoing deterioration is actually an abuse of privilege. It's self-serving, forcing those costs onto other owners. The costs don't go away, they just get pushed onto the shoulders of other owners. And I believe you're going to hear it called conflict of interest by either Joel or George later on. So we created this webinar to build recognition of the problem and to encourage responsible budgeting. So guys, Joel and George, is that a pretty fair explanation of the predicament that we're in?
It sure is, and it's interesting to note that 71% of the participants are board members, and our statistics show that 70% of associations are underfunded. A coincidence?
Hopefully that's a coincidence. I hope these are the 70% they're going to take this message back to their associations and start dropping that percentage down, because they're going to understand more and more that they're the ones in charge. Okay, well, let me get one more hands raised before I turn it over to Joel. Ready for Joel and the beginning of our two guest experts? Give me a hands raised. Excellent. Okay, thank you very much. I'm going to click hands down. And now I'm going to turn the microphone over to Joel Meskin. As you heard earlier, Joel is uniquely qualified as both an attorney and an insurance expert. He's a specialist. He's got specialist designations in the field of community association D&O Insurance and as an attorney. Now, that D&O Insurance defends board members who are accused of wrongdoing in the normal course of running the association, which includes doing things like setting the budget. So, Joel, welcome, and please tell us how we got here. Joel, I've got you on mute. There we go.
Just testing, Robert. Thank you, Robert. And I really appreciate so many board members taking out the time to listen to this. I spent a lot of time speaking with board members all around the country, and I think what got us here is a consequence of really, why do people choose to move into a community association, a common interest development? And generally, as I understand it, with all the people that I've worked with and spoken with over the years, it's basically because they want to protect their two greatest interests, that being their home, which is in most cases their biggest asset, and their lifestyle. And the challenge is, and I think what got us to this problem is, board members and unit owners do not truly understand what their obligations are in living in a community association and what the benefits of those obligations are. You know, people have this thought that aren't reserves something for the future, and in my opinion, that's one of the greatest misnomers that cause problems in community associations. Even though they seem like they're a future, they're not a future issue. For all intents and purposes, whether you pay now or you pay later, they equal the same thing. Some people say, I'll move, I'll die in 5 years, why should I pay? Well, one reason is, if there's a large underfunded reserve, which is there to protect the two greatest interests, that's going to have a direct impact on your market value when you do go to sell, if they're not properly funded. As Robert said, you know, there's an obligation by the association board who has to put the association and not themselves or the individual unit owners first. And one of the ways that they tragically don't do that is by not properly funding reserves. You know, one thing that always amazes me is that if you don't pay your insurance, they're going to cancel you. If you don't pay and properly fund the reserves, the result of there could be varied, and very often leading to somebody bringing an action against you as a result of their home value dropping.
Yeah, it's not like the roof goes away and says, sorry, I'm done.
Yep, the bills still pile up, even though they may not say that due upon receipt, but we know that one of the things in associations that we try to avoid at all costs is surprises. These are budget-driven entities, and you want them to continually, gradually grow, but without having any big dips or spikes. Nobody has a crystal ball, so we don't really know exactly how much, but that's not an excuse, how much we need. That's why we have reserve specialists. These are people who, you know, they have the expertise, they have the algorithms, they're able to look at what you need and give you an indication of what you need to put away on a monthly basis to avoid, you know, surprises, special assessments, all those things that people living in community associations really don't want. And that's one of the reasons, again, that they move into a community association, because those, and hopefully those who are going to have more experience in them until they decide to become board members, will take care of. One of the second misnomers, and this is, I can't tell you how many times this really gives rise to claims. There is nothing in any governing document, there's nothing anywhere that says the board's obligation is to save money. And one of the key areas that statement is applicable is with respect to funding reserves. You know, it's, again, nobody's going to, however it may manifest, cancel you because you're not funding reserves, but you know, it's going to impact each and every one of you. The board, as you may or may not know, but you should, you're the risk manager of the association. The board as a body is a risk manager of the association, and the key obligation is to protect, preserve, and enhance the association. Again, that's why people choose to move into an association, because they want the governance, the way that it is put together to be able to best protect the common elements, protect the lifestyle by following rules, but even more so with properly funding reserves, because we know things are going to wear out. We know on a specific time, and again, people may have an idea of how fast the roof will wear out, how fast the concrete or this or that. But at the end of the day, you have reserve specialists like Robert, his competitors. You know, Robert's done 50,000 of these within his team, you know, so you would think that they wouldn't be in business today if they weren't getting it substantially right. And I can guarantee you that by the board not using a reserve specialist, you're probably going to be, in fact, you know, George and I can debate this, but I think you could be breaching your fiduciary obligation. A lot of times.
Watch the use of that F word, will you?
I think George, yeah, you're stepping on George's territory. I think he's going to have some time on that.
That's right, that F word. Yeah. But so the board really has to take this responsibility. You have to take it seriously. And who says that the board has this? You look into the governing documents and you really see what is the obligation of the board, and it's really to protect the interests. There's nowhere in any of these documents, and if any of you have governing documents, CC&Rs, conditions, covenants, and restrictions that indicate that you that you're supposed to save money on behalf of the association, let me know, send it to me on the honor system, and I will buy you dinner. You know, under COVID, I might have to send you a Grubhub to get this going. So
I like that challenge.
Yeah, but it's true. I mean, I'm sure I would be shocked when George comes in, he could maybe indicate how many he's seen where that is a provision. So what are the basic risks in a community association that you have to protect? There are two things. One are unexpected perils. That's what we all know about. And how many of us would think to live in an association and wouldn't yell and scream if the board wasn't purchasing insurance? We protect ourselves with respect to unexpected perils, and they may never happen. On the other hand, the wear and tear that is really framed by the reserve study and is a blueprint for me as an insurance professional to tell me really what needs to be insured, you know, with respect to unexpected perils. But we know that the reserve study items are going to happen. You know, the roof is going to wear out. Maybe not in 18 years, maybe not in 24 years, but I'll tell you, reserve specialists get it a lot closer than you or I would get it. And there's just no reason not to properly fund those, because where I see it, and I see it on the other end, as I indicated, I've dealt with many a director and officer liability type situations, and failing to do this, you're going to get sued, and, the one hand, it's, I'm going to probably defend you if you have my policy, but there are some D&O policies out there that do not provide coverage for what we call non-monetary claims, which this is really, for all intents and purposes, it's not a monetary claim, and we will not provide and become the reserves that you did not properly maintain. The board has a risk management team, and this goes to, we have brilliant people on boards. We have attorneys, we have architects, we have, landscapers, we have plumbers, we have bankers. Keep in mind that those professionals, in their capacity as a professional, they're not going to be covered under the directors and officers liability policy. So one of the ways they have to preserve the assets of the association, in addition to funding these reserves, is to use professionals. You may determine as a board when things are going to wear out, this or that, but you're not covered if you make a mistake. You hire somebody, a professional, and I guarantee you, they're going to be covered by their own professional liability or errors and omissions. Similar thing with the managers. They're professionals to help you identify, inspect, and review the things, and maybe down the road you have to tweak the reserve studies. One of the problems that we always see, and it just is the same theme that I've been talking about, and hopefully it's you're sick of it at this point, but it's all about, you can't be penny wise and pound foolish. At the end of the day, somebody's going to have to pay, and no matter what happens, no matter whose fault it is, at the end of the day, the association's going to have to pay. I tell associations that, if you're not covered because you properly funded a reserve study, or if you're not covered because you bought insurance that was maybe cheaper and doesn't have the breadth of coverage, at the end of the day, you're going to be self-insured for those items, because you're going to have to pay. It's different if you're living in a single family house where you can do whatever you want. You're not in an association. If the Space Lab drops something into your roof and creates a hole, and you like that skylight, you don't have to do anything. If it happens to a condo or to a clubhouse, it's going to have to be fixed. So that's why you have insurance to that degree, and why you do your reserves. Okay, what I'd like to do now is pass this over to George. For those of you who don't know George, he is, in my humble opinion, one of the top community association attorneys in the country. I'd put him in the top 5 in the country, and I think, I think his work speaks for itself, and hopefully you'll listen to him. Hopefully you'll read some of his articles, and I think you'll learn a lot. So George, why don't you take it over?
Very nice of you to say those things. I appreciate it, Joel, and good afternoon, everybody. I want to echo how much I appreciate and recognize that 71% of our participants are members of the board of directors. You do not hear thank you enough, so please hear thank you for all that you do in keeping your associations functioning. You have in front of you a great cartoon. Pretty amazing what the HOA is able to do with this place. You'd never believe we're in our 8th year with dues of only $35 a month. Funny, maybe. Realistic, yeah. In fact, I have an association that until maybe 6 years ago, the board of directors for at least 10 years would stand up in front of the membership at the annual meeting every year and say, this is the blank year that we can stand up here and say that there is no increase in the payment or the assessment of dues. And everybody would cheer and, wow, isn't that wonderful? And it was a real source of pride that they could hold the line for more than a decade. Well, then the reality of what happens when you don't raise your dues, and specifically when you do not put money aside for reserves, they own their own underground cast iron water pipes. And do I need to say any more? And they were approaching 45 to 50 years old. Over the next few years, the association had to spend more than $3 million to replace the water system, as well as roofs and gutters and various other things. And suddenly, the cheers were replaced with, well, why did the board do that? And how could we let this happen? And on and on and on and on. But the bottom line was, everybody thought it was wonderful. But the reality of it was that they were not adequately funding reserves. And they, in not doing that, created some issues for themselves legally, which goes to the general description of the roles and duties of the board of directors. Boards of directors in every state are subject to whatever the state's nonprofit corporation code is. And with few minor changes, it's known as a uniform act or a uniform law. And it's pretty much the same document in every state. And under the nonprofit code, a board of directors of a nonprofit corporation has a duty of care as well as a duty of loyalty. The duty of care is known as the good business judgment rule, and a duty of loyalty is that F word, fiduciary duty. I say this to all of my clients, board members. You can use whatever F word you want, but please do not use the fiduciary word unless you really know what it means and how it is applicable. So the first thing I want to talk about is board of directors' duty under the business judgment rule. The business judgment rule, again, is in every state, and it says board actions must be within their authority and power. The decision must be in the best interest of the association, and the decision must be made based upon reasonable inquiry. And in parentheses, the buzzwords are good faith, loyalty, and prudence. And good faith means that the board of directors believes that the decision that they are making is one that is based upon informed information, where the board is not blindly making a decision or guessing in making a decision, but decisions are made with information from experts. And an expert can be on the board if the person's credentials are correct, or you need to go outside the board if you do not have an expert on the board to give you advice. But when making decisions, especially when it comes to funding reserves, board members have to act with information. And if they don't, then they're just guessing, and they're guessing with the most people's biggest asset, their home. The duty of loyalty, which is the fiduciary duty part of this, I'll discuss in a minute, deals with making decisions that are in the best interest of the corporation, regardless of how they affect you personally. And then the third point is all decisions must be based on reasonable inquiry, meaning you make an informed decision. And so the process, and it goes to, we do not know how much we're going to need to replace the roofs. And rather than going around the room and asking each board member what they think, a board has the obligation, in order to make an informed decision and act in good faith, to inquire as to the answers to those questions. And as it relates to reserve studies, the inquiry goes to reserve specialists like Robert, who have done thousands and thousands of them. And when I'm talking about a reserve study, we all are talking about reserve studies, we're talking about where an expert comes in, surveys, meaning inventories all of the property, notes the current condition of the property, estimates the remaining useful life of the components, and gives a projection on the cost of repair and replacement, so that the board that asks for the report, as well as future boards, have something, a good thing, for them to make an informed decision on how much or the level to set the contribution to reserves in each year's annual budget. So that's the process of making the decision first to hire and then to obtain the report from the reserve specialist. And then we have to look at the fiduciary duty aspect. Under both good business judgment and fiduciary duty, you have to act in good faith. Despite people using the fiduciary duty word somewhat generically, the screen shows there are only 4 things that are a breach of fiduciary duty: not acting in good faith, failure to keep the confidences, failure to disclose your conflicts if you are doing business or a company affiliated with you is doing business with the corporation, and you cannot use your position on the board for personal gain. And if you remember that slide that had the bullseye that Joel had put up, what we're getting at is this, and I don't think most boards or board members think of it this way. If you're on the board of directors and you, first of all, the board says we need a reserve study done, and you veto that or attempt to veto that because you do not want dues to increase because you can't afford it or for any other reason. Or once the report is prepared, you find fault with all points of it because, again, you do not want to see that amount added to the budget, either because you can't afford it or you're afraid of the effect on the sales of the units if your assessments go up in relation to surrounding properties in order to fund the reserve account. But if you do that, first of all, you're not acting in good faith. And when I say good faith, I'm talking about in good faith for the corporation. You're members of the board of a nonprofit corporation. And if you were acting as board members and you had shareholders, it certainly would be a breach of your duty and failure to act in good faith if the corporate board did not put away money to maintain the physical plant and be in a position to handle repairs. You would say that that was reckless conduct by the directors, but it's amazing how when people become members of the board of an association, they don't accept or recognize or want to accept or recognize that they have the same duties in making business decisions that members of the board of any other nonprofit have. So not going forward with that means if you do not act in the best interest of the association, you will have breached the fiduciary duty. And so what are the consequences of that? Well, first of all, your neighbors aren't going to like you if that's important to you. But beyond that, this is true again in all states, that if you breach your fiduciary duty, the law says, and I just love this, that you will be disgorged of the personal benefit you received.
Sounds like a horrible thing.
Boy, doesn't that sound painful?
Yeah.
And then people always ask, well, can I be personally liable? What can they do to me? And the answer there is, it's called the economic loss rule. And if a board member or board members intentionally do not address reserves and the funding of reserves, and then there is a big special assessment or a ginormous increase in the annual assessment, the members of the association would bring, if they wanted to, if they were so incensed, they could sue the board members individually. And if in fact the board members did not act in good faith and certainly did not act in the best interest and acted in their own best interest by avoiding the increases, those individual board members, if proven against them, would be liable for the loss, the economic loss that each owner suffered or will suffer because they don't have the reserves in place and they're not in the ability to respond to get things done. So it can be very serious. I have not seen that yet, but that is the bottom line on what happens if you breach your fiduciary duty. So we don't want you to breach your fiduciary duty. We want you to accept that you have to understand, investigate, and make informed decisions as it relates to reserves. And the only way you can know in order to protect yourself is to get a reserve study. Last point, the issue with getting the reserve study is yesterday afternoon I had a call with an association that has a dam that's failing, and they're going to have to do a special assessment. And I asked them if they'd had a capital reserve report prepared, and they said, oh yeah, we had that done back in 2007. And I said, and what's the updates been? And the answer was, oh, we've never had it updated.
Yeah, that's trouble.
It's a lot of trouble. And you ask them why, and they say, well, it cost us X dollars to have the first one prepared, and we didn't want to have to spend that money again. And Robert, correct me if I'm wrong, but the initial cost for the first report is nothing like what I'll call the updates or the maintenance of the updates going forward. Isn't that correct?
Absolutely. The update reports are a fraction of the initial cost.
And so if we go back to the first slide about sticking your head in the sand, you can say, well, yeah, the board did that in 2007, so we had one performed, regardless of whether it's 13 years ago or it was done recently. Simply saying, yeah, oh, we had one performed isn't discharging your duty. Your duty is to have it performed and then to act upon it. And that is your obligation as board members.
Yeah, thank you, George. It's a matter of choosing what you're trying to do. Are you going to adequately fund? Are you going to minimize the assessments and increases? Kind of like that picture that Joel actually showed earlier. What objectives are you pursuing, or are you going to follow your role and responsibilities as a board member? Well, let me take just a moment and talk about what actually adequate reserves looks like, and what is that? How much is it? And so a number of reserve study providers across the country got together back in early 2018, and we were able to come to a consensus. We were pushed towards that, or driven towards that, by so many people like George and Joel, who said, you know, we need to tell our clients to have adequate reserves. But what does that mean? What does it look like? Well, you can see it on screen. The paraphrase is that it's having enough cash to perform the reserve projects on time without reliance on additional funding. So it's a little bit of now and a little bit of later, having a funding plan that shows that you have enough cash now and projected through the years, balancing your income and expenses to show that you're going to be cash positive. So there is that now and later element. So it's all about good faith. Projecting to be cash positive or better. Having a little more margin is always good, because again, the cost of reserve deterioration is as real as any other bill. You can't run away from it. Closing your eyes or wishing it away doesn't make it go away. It just falls onto the shoulders unfairly of future owners and future boards. There's no benefit to ignoring those costs, because those costs are going to happen. As Ben Franklin said earlier, and show it again, by failing to prepare, you are preparing to fail. So you need to gather that cash together and be doing your responsible part to move the association forward. Joel? And again, I show you muted, Joel.
I apologize. So now we have to determine, how do we move forward? hopefully we're speaking to the choir and most of you are really in very good shape. And we won't ask those of you who aren't in good shape to raise your hands.
Good.
Because then you might not listen to us ever again. But we're not here for you to like us. We're here to give you a, tell you the truth, really what we have to do with. We know that deterioration is going to happen, wear and tear happens. We know that you have a requirement pursuant to the obligations and principles that George indicated to protect the assets. And the reserve expenses are as predictable as, everybody always wants something to be scientific. Just listen to our president and and Biden and everybody, let's go by the science. Let's go by the science. I'll put up Robert's predictions or his colleagues' predictions, against most board members. Some board members are brilliant, but at the end of the day, you're required to use a professional. And we know that the board of directors is the risk manager. And so what you need to do in these budget-driven entities is do whatever you can to, number one, have the best insurance available. Number two, properly fund the reserves. I call reserves insuring the uninsurable, that we need to, as you have to look at paying and putting away the preserves as if you are paying your monthly installment on an insurance policy. And I think the board needs to do that. I think they need to educate the association that that's why it's being done. Because when the association, they move in, they look at a unit, they take a snapshot of the community. 10 years later, they want that snapshot to look significantly, substantially the same. So if we don't do that, we're going to have special assessments. And I think most of you, especially the board members, know how fond unit owners are of that. If we ignore what it really costs in the associations, that's going to be a slippery slope for most of us, because it is there and you will get sued. You may be defended, you may not be defended, but at the end of the day, you're still going to have to pay it. And some owners may need to move. I mean, it's a hard truth, and I would hate to be the one to, to push a unit owner out, but sometimes in association, a certain house is just not maintainable. And I hope this really gives some people some good thought on how to push this forward. George?
Agree. Sorry, I had to unmute. I mean, it again, and hopefully we're preaching to the choir, but if you do not plan for the inevitable, the certainty, not inevitable, but the absolute certainty that components of community associations wear out, just like they do for us humans. And the older we get, the more expensive it gets to keep us going, to keep us to where we are functioning. And a roof functions just like we do. And so you've got to make sure that you're discharging your duties, because you will affect not only your property values, but the values of all of the people in your community. If you act and make a decision based on an informed decision, you've acted in good faith. And courts will not second guess decisions made by boards of directors if they were made in good faith, meaning they were made after a reasonable inquiry. Courts don't look at the results of board decisions if they've acted in good faith. They will not say, oh boy, that was a stupid decision. It very well may have been, but if it was based on informed consent of the board and information, then what the court is saying is you're allowed as a board member to make a mistake, so long as you follow the process of making the decision in good faith. So it is an important part of the board's duty. It may be very unpopular. I said earlier in the seminar and the other previous one that I picture George H.W. Bush standing up and saying no new taxes, and you know, everybody cheers. But the reality of it is, like in my story about my association, those buildings and those pipes were aging while everybody was standing on top of them, cheering the board of directors for ignoring the problem.
Yeah, thank you, George. We in the reserves aid profession were challenged a couple of years ago to get a good definition of adequate reserves together, and we were able to do that. And now I want to pass that challenge on to the board members and the managers here in our audience, that indeed it's now time for them to have a plan. As you've heard many times today, the reserve expenses are inevitable, they're predictable, and they're a bill like any other bill, and it's the only right thing to do is to plan for that inevitable expense. For those of you who are with management companies, look at the reserve status of the client. You can guide them forward towards a future. You know that the lower the reserve fund, the more tension and trouble and special assessments there's going to be at the property. It's just not going to be a very profitable association to manage. It's going to start to suck a lot of time. And want to leave you with a nice helpful hint. Choose your words carefully. The expenses may be in the future, but the contributions are just ongoing, paying the deterioration bill. The deterioration of the roof this month, the deterioration of the fence this month, paying that deterioration bill, it's everyone's obligation as long as they own a home in the association. We want to encourage you to feel that a great future is within your grasp. It's all the choices that you make, how much to set aside in reserves, having the courage, understanding the why about you make that, the why you make that decision. But we encourage you that with a bunch of wise decisions, you can set your association towards a future without special assessments, a future that is a smooth running association that has the cash to do what they need to do on time, and a future with maximized home values. So as we wrap it up now, on behalf of Joel, George, and myself, I want to thank you for attending our program. We hope you were able to learn why actually setting aside adequate reserves is a fundamental legal requirement for all associations. It's not a matter of looking at what your state law says about funding. It's about being a board member at your association and being responsible to care for those assets. So now with the time remaining, I'm going to turn the microphone over to Paige, who will serve as our MC for the Q&A time of our program. Paige.